Welcome, everyone. We're going to take a few minutes to let people join before we get started. If you have any questions during our webinar today, feel free to pop them in the chat. We will get to those at the end. We've got some time for Q&A. Thanks for being here. Let us know in the chat where you're joining from today.
Ooh, I see someone from Banff.
Oh,
Nice.
yes. Amazing.
Saskatoon. Nice. People from everywhere here. Nice.
Wonderful. If you've just joined in the last 30 seconds, we're going to get started shortly, waiting for a few more people to join. Let us know where you're from in the chat. And if you have any questions throughout the webinar, please also put those in the chat. We will get to those near the end of our session today. I think we can likely get started here. I've got a lot of people from a lot of places across the country, which is great. So again, welcome everyone. I'm Natalie. I'm the event manager at HUME by Employment Hero, and we're excited to have this webinar today. We're going to get right to it, and I'm excited to introduce Matt Byler, who will kick us off.
Good afternoon, everyone, and welcome. I am the Senior Manager of Strategic Partnerships here at HUME by Employment Hero. We're a modern Canadian employment software solution, proudly supporting over 6,000 businesses across Canada with everything tech-wise from HR and payroll to benefits and talent management. I personally have been in the space for close to about 10 years now, working with multiple different vendors like Dayforce, HiBob, Rise, and just super thrilled to be part of the employment or HUME by Employment team, Hero team. Now, over this time, I've realized really one main thing that I want to point out. And end of the day, technology is only going to solve about 75 to 80% of your needs. It's truly reliant on the expert people in HR, the experts in transformation, optimization, change management, and daily maintenance of HR efficiencies to achieve peak performance around employment management. In my role now, I really only have the one key focus, and that's to look out for the best interests of our customers. And by realizing through my experiences that tech isn't everything, we found that partnering with key experts in HR and law, such as Business Serpa Group and Navio Law, we can provide much more value and a lot more fulfillment to our customers. So without further ado, I'd like to showcase some of that added value our partners can bring with their key insights in today's webinar. So please welcome Laura from Business Sherpa Group and Justin from Navio Law.
All right. Can everybody hear me? Okay. Okay, perfect. So thanks everyone for joining us today. So our webinar today is we're going to talk about navigating workforce change. And I hope so, but before I start that, I hope everyone's enjoying the summer so far. I guess it's actually not technically summer yet, but it always seems that whenever the weather reaches about 10 degrees here in Canada, we think it's summer because, you know, we have such a long winter. But I hope everyone's enjoying the nice weather that we're getting. As Matt mentioned, my name's Laura. I'm pleased to be co-presenting today alongside Justin from Navio Law. We thought a great topic to present with everything going on right now, such as economic uncertainty, restructuring, shifting priorities. Layoffs can often feel like the immediate or obvious path forward, but they're not only it's not really the only way that we have, and in many cases, not even the best long-term solution. So what we want to do today is really open up that conversation and explore some sustainable alternatives, things that can help organizations reduce costs and still protect your people, the morale and the overall stability of the organization. So I'll be covering HR-driven solutions like workforce planning, temporary salary adjustments, job sharing, and internal mobility, tactics that you can, you know, what organizations can do to reduce costs and preserve jobs within your organization and the skills that the people hold. So after, you know, that part of what Justin's going to talk about, he's going to walk us through legal considerations around layoffs and employment changes, what you as employers, or if you know what you need to understand about terminations, the obligations that are required, the risks, compliance, and how to navigate these decisions lawfully but also responsibly. So whether you're in HR here today, operations, leadership, our goal is to leave you with actionable compliance strategies to handle workforce change thoughtfully and effectively for your organization. So let's get started. So with strategic workforce planning, before we talk about alternatives to the layoffs, we need to understand what roles we actually need now and going forward in the future. So this is about stepping back to assess what your organization needs now and also going forward by identifying the critical roles and aligning staffing to long-term goals and using scenario modeling. You can make informed proactive decisions. So it's not about reacting under pressure. It's about asking the right questions earlier on to avoid unnecessary layoffs and to build a more resilient workforce. So the first thing we're going to talk about is strategic workforce planning, how to realign your workforce for making cuts. So the first area is under current versus future needs. This is really about taking a step back. What does your organization need right now to keep operating effectively? And what will you need 6 months from now, a year from now, or maybe even further out? Often we're staffed based on what made sense last quarter or last year, not what aligns with our future direction. So the first step is mapping out current roles to your upcoming goals, the strategies for the organization. Are we over-resourced in one area and under-resourced in another area? Could some roles be consolidated or refocused? So those are kind of some of the things that we need to look at. So when it comes to critical role identification, you want to get really clear on which roles are really truly critical. And that's kind of more of a nice, you know, nice to have versus a need to have. These are the roles that if they disappeared tomorrow would seriously impact operations, customer service, revenue, or compliance, those types of things. So it's not just about job titles, it's about functions and outcomes. Sometimes that might mean identifying high impact individual contributors, not just leadership positions. So who's really performing and who really is, you know, contributing to the goals of the organization. Once you know which rules are mission critical, you can prioritize retaining and supporting those, even during the rough times. And then the next area is scenario modeling. So this is where the planning becomes proactive instead of reactive, something that we all we all ideally want, but sometimes it's not possible to do. So we really want, for a takeaway for you is to be proactive instead of reactive. Scenario modeling means building out a few what if workforce plans based on different financial or operational situations. So really doing the talk around, what if this happens? What should we do? In this situation, what would we do? So what if revenue drops by 10%? What if key product, for example, is delayed? What if you need to scale back a department temporarily? When you've done this kind of modeling in advance, you're actually in a much better position to pivot quickly if needed without defaulting to the automatic assumption that we always make, which is layoffs. So it also helps you get, the buy-in from leadership because you're showing a thoughtful, data-informed approach, not just reacting under pressure. So strategic planning isn't about having all the answers. It's about asking the right questions early enough to make smarter decisions. And if it's one of the best ways to avoid knee-jerk response of cutting headcount when challenges arise, which no one likes to do, and it's always seems like the solution. So I think from that, Matt, you have a question?
Yeah, I've been waiting patiently, but that's great that you mentioned that. This might actually be more of a legal question, but before you finish the strategic workforce planning, like, are there any legal matters that you should be considering?
Yeah, maybe I'll jump in then, Matt. Can everyone see me? I still just see Laura. Okay, perfect. Hey, everybody. So before I begin, I just need to do the shameless lawyer plug of this is always legal information and not legal advice. But I'll do my best also to answer every question from a national perspective, because I know there's people all across the country. And with everything I say, I'll probably repeat it throughout the webinar, but everyone should always quickly double check the rules and regulations in each of their province. They are similar across the provinces, but often similar enough that it's easy to make a mistake in those little details. So whenever someone is talking about workforce reductions, I was really excited to do this webinar because I usually say, hey, have you chatted with HR and thought of the full breadth of things, and introduce them to a variety of ways that they can restructure their workforce. And then I usually take them through some of the things to think about. So I always say, hey, pull together everyone that you're thinking about making changes with. And usually the first thing I do is have them run through with me, or on their own, their employment agreements, their policy books, really any of the written materials they have with their employees, because that'll really help you understand some of the risks there. I would say the number one thing that goes wrong, when people come to me and they haven't engaged me before they've made the reductions, is that they think they have valid paperwork when in all reality they don't, right? So I always say at a very first step, look at all your paperwork and with your counsel and just make sure that it's up to date. And that is key because in every province, Employment Standards Acts are actually really the minimum. They're not an overriding legislation. And especially here in Ontario, courts have said, if you don't properly reference the sections of the act you want to rely on, we're going to assume you've actually contracted out of this. So you do have to review your paperwork every time you want to do this. And I usually do this with all of the HR partners I work with, and everyone at the company, to really help us understand the spectrum of risk. And I'll talk about that a little bit more when I get to my slide there. And then also at the same time, I always say, be prepared with your history, right? As you're thinking of all these employees that you may want to move or reduce, or talk to, think about the history with these employees, because that will always color any demand letter or any claims you get later. And sometimes that will inform the advice that your lawyer will give to you or your HR partner.
Mm-hmm. I have a legal question that I want to ask you specifically around the workforce planning. Like, when you're restructuring roles or like reassigning responsibilities, but without changing job titles or compensation, what are the legal risks around that?
Yeah, what I usually see as the number one problem that occurs with that is people don't paper changes to people's job duties and titles as they evolve. And that really creates a problem because, especially in Ontario, courts will say, oh, well, this person started 5 years ago. They've got an employment agreement for a basic customer service associate. And they were stellar and they've moved up the ranks and now they're managing 10 or 15 people. Their job duties, have expanded, or sometimes even their title really hasn't changed, but they're doing more than they expect. And the problem there is then courts will say, the job duties and this bargain that everyone entered into when the person was employed doesn't really match the reality of what's going on today. And they may not find that you have a written contract with that employee. So I always say, as you're making changes, even if it's not to the title itself, you really should update the job description and duties and responsibilities of an employment agreement, either with a form letter, or I usually always say a brand new employment agreement wherever you can, especially if you've gotten an updated copy with your lawyer. And I do say people should check in every couple of years on an employment agreement. And that's because laws change all the time. And courts are always creating higher and higher standards since COVID for employers to really keep these things up to date and say you have the financial firepower. You really should make sure these are up to date so the employee really understands what they're entitled to. And they won't take the stance they used to in some provinces where they say, well, at the time, the employment agreement was correct and you did comply with everything and you gave them greater rights than the employment agreement because you knew the laws have changed. They're really kind of creating that standard to say, hey, you should get that updated, especially if there were reasons along the way to do so.
Yeah, thanks for that.
Yeah.
Yeah, go ahead.
Go ahead, Laura.
I was just gonna pop in and say it is so important, like Justin said. I mean, I know from my perspective as HR professional, I know some of my coworkers, we always get our contracts. I mean, we're very, up to date on things like that, like what, employment standard changes and such, but at least once a year we get our employment contracts looked at to make sure that the wording is really up to date. And so we rely heavily also on the legal aspect from it as well. So always something that we recommend as well. So, all right. So I guess we can move to the next one. So before turning to layoffs, obviously, and like Justin was saying, like you'll hear probably a lot of things repetitive, and it's not because we don't have a lot to say. It's because these are the trends we're seeing, and these are the areas that we really want to make sure that we're getting across to people, and the things and the trends that we're finding. So we really wanted to integrate the things that are very common. So if you do hear repetitive things, that's obviously why. And so one of the next things that we want to talk about is before layoffs, exploring flexible compensation strategies that ease financial pressure while keeping the team together. So temporary salary reductions, with leadership leading the way, voluntary leaves or reduced hours and performance-based bonuses can all provide cost savings to your organization. So these approaches maintain morale, they build trust, and they protect your culture within the organization that you're really trying to keep up. So helping you stay lean without losing the talent that you worked so hard to get and to train and to develop. So what we're going to talk about things like salary adjustments and creative compensation solutions, how to reduce the payroll costs without reducing headcount. So there's a lot of different ways that we can do this. Obviously, when layoffs are on the table, the biggest pressure point is usually the payroll, right? So, but instead of going straight to letting them go, there's some flexible compensation strategies that can ease that pressure while keeping your team, intact. So let's walk through a few. So some of the things that, could be recommended are temporary salary reductions. So this one can feel tough, but when it's done transparently, and that's a huge thing, And fairly, employees often prefer to seeing colleagues laid off or themselves being laid off. So if they're understanding the situations, you're transparent about it, often you'll see that. So temporary salary reductions, especially when leadership takes the first or the biggest cuts, can spread the financial impact more equitably across the organization. But you need to make sure to be very clear. So this is temporary. It's based on current business conditions, and there's a plan to revisit or restore these salaries when things improve. So having that agreement and that, conversation and making sure you're being transparent is very key. And they're more likely to accept short-term pain if they trust the process and the intention behind what it is that you're going for. Another one is voluntary leave or reduced hours. So another approach is offering voluntary unpaid leaves or reduced hour arrangements. Again, offering. So not telling them this is what you're doing, you're offering these options up to them. You'd be surprised at how many employees opt in to something like that. So whether it's to spend time with family or travel or manage other priorities, these can be structured as sabbaticals, maybe 4-day work weeks. Who doesn't like 4-day work week? Or seasonal slowdown. So even temporary shifts can provide significant savings within the organization. Um, the key to frame it is optional. Again, supportive and potentially beneficial for both the business and the individual. It's a softer way to reduce labor costs without severing those employment relationships. Again, I don't like the trends that we're seeing is people are wanting, reduced hours. They're asking for it. They're coming to the employer to say, what would a 4-day work week look like? And I think it has to do with, what's been going on out there, with, since people started working from home, where they're working remotely, or they want that more time work-life balance. And so we're seeing things like this anyway. So having that option during these tough times you'd be surprised at how the buy-in would be. And then another option would be performance-based bonuses instead of raises. So this is something that we're starting to see. Um, it's something where I do have a lot of clients that are coming in looking for performance-based bonuses and as opposed to raises. So it they aren't always, as we know, annual raises are not feasible based on the conditions and what's happened throughout the year and business. So performance bonuses are more of a really good middle ground. So instead of committing to fixed salary increases, you reward results. So what does that look like? So you're only increasing the compensation when there's real value generated. And we've been working with organizations on what does that look like? So implementing things like performance reviews. And I know that's a familiar term and people may already be out there doing that, but really structuring it so people understand that their performance is how they earn their money and not just automatic increases every year. It keeps the employees motivated. It shows them that they're still recognized for their efforts, even if budgets are tight. And it also gives you, as an organization, more flexibility because bonuses can be adjusted or deferred based on how well the business is performing. The goal with creative compensation strategies isn't to underpay people. So we don't want to give that impression. It's to buy time, build that trust with your organization and avoid more permanent damage, like losing the talent that you value, or breaking the culture of your organization. So when it's done thoughtfully, these options can really help the organization to stay lean and also humane.
I think Matt has a
Matt?
question more.
Yeah,
Yeah.
yeah. So, like, just looking at this temporary salary reductions, I'm like, wow, like, there's got to be some type of legal component. So, like,
Mhm.
Justin, like, for reducing salary temporarily, what should you be looking at from a legal standpoint, and for the employer, like, how do you keep that legally sound?
Yeah, so this one is a two-pronged approach, and I always advise employers, you can really get pretty creative and do anything that Laura has suggested that employees agree to, right? And I always say that's really the first step, the same as Laura advocated. I always say, the first step is really to have these discussions with them. And I've always been surprised at the amount of employees that take up some of these creative solutions because they realize what the economy is like, or the industry, right? So they realize it helps secure their job for the future. If you're in a position where you need to do it from a mandatory perspective, I always say, be very careful, be very clear with the employees in simple written letters of what the reduction is, how long the reduction will take effect, and when they expect to see the reduction lift. And within that, most provinces have a spectrum. So about 10%, most courts wouldn't really entertain a discussion on that. They would say, and have said in case law, that 10% is cut is better than 100% cut. So, it does work in favor of the employer there. When you begin to get more higher than that in 15 and 20%, that's when courts begin to say, hey, that's kind of constructive dismissal. It's a big change, hard for the employee to budget. On the alternative side, if employees agree, I always say papering it is king, right? And keeping it, despite the fact that I'm a lawyer, I always say keeping it as simple and clear as possible, rather than giant letters. I always say just as simple as possible with the minimum amount of language that's required to protect you, right? So, right, if they're agreeing voluntarily, it's just, sometimes it's just setting out that history and then what they're agreeing to and when it'll return to normal. And like Laura said, it helps to build trust, and it also knows what everyone is working towards so that they know when everyone will return to a regular salary. And especially like now it's the summer, right? I'm shocked at one employer the number of people who were like, no, I'll go part-time, I'll do 4 days, for the summer, like happy to do it. They realize, in this case, that the industry, really is going in through hard times, and they're just happy that their employer is exploring ways to keep as many people employed as possible.
Absolutely.
Yeah, thanks, Jess.
So instead of reducing headcount, let's rethink how work is structured. Okay. So going to the next area here, job sharing and flexible work arrangements, it lets employees split a role. So some of you may have this already, or something that you've thought about, and it's definitely a way that can assist with these types of things. So reducing schedules across the team can create collective savings, and flexible project-based or remote roles help retain skills while cutting those fixed costs. So these options are financial relief and employee friendly. Flexibility and keeping your workforce engaged while adapting to change. So things that we're going to talk about today for this is job sharing and flexible work arrangements. So creative scheduling to preserve the jobs and to boost adaptability. So another way to pivot without those layoffs is by looking at how work gets done, not just who's doing it. So flexible work arrangements and job sharing can offer powerful alternatives to full-time employment cuts. These options give you room to reduce costs and give employees more flexibility, which, as we've said, many actually will welcome. So job sharing between two employees. Let's start with job sharing. This is two or three, or however many how you want to see it, is where they split the responsibilities of the job and the compensation of one full-time role. Work well in roles that have a steady, predictable workload, and especially when you have two high-performing employees who both want reduced hours. So, for example, if you've got two team members who each want to work part-time due to personal circumstances, job sharing lets you keep both of their skills in-house without doubling the cost. So a lot of the time we have great employees, but we just don't have the work for both of them. So this is an option, and you want to keep both of them. So it does require some coordination, obviously clear communication, things like shared calendars and maybe some overlap, but when it's done right, it can actually boost the productivity and the coverage. Another thing that is possible is reduce schedules across the department. So this is reducing the hours more broadly, not just individual job shares, but maybe trimming a few hours per week across the entire team or department. Again, this goes back to, a lot of the time too, like Justin was saying, early summers, like early Fridays, like we have that a lot, where we give the employees the option if they want to be off on Fridays or Mondays, talking about that. The key is transparency again and fairness. Be open about what the business needs are, and where possible, give people a say in how these reductions are structured. So this approach can feel less disruptive than obviously layoffs, and actually reinforces a sense of shared commitment. And the other thing too is remote, or contract-based project roles. Don't overlook this type of model. So especially if you're scaling back core operations, but still have short-term initiatives or specialized needs. Some employees may be open to shifting into contract roles temporarily, or working remotely on a more flexible schedule. So as again, we've said, working remotely is a huge thing right now. People are very, very, interested in that type of option. This can reduce the fixed costs while keeping critical work moving forward. So it's a great way to test different workforce models, again, without permanent changes to your org charts. We see this a lot where we do pilot programs or pilot projects, where an organization wants to test out these types of changes. And also ultimately looking at if there's roles where physical presence isn't required and remote work options can widen the talent pool and save on your overhead. So flexible work isn't just an employee perk, it can be a strategic lever to manage through uncertainty. So by getting creative with how hours and rules are structured, you can keep more people employed, obviously, and maintain the continuity within your organization and come out stronger on the other side. Matt?
Yeah, I
You
have a few
question?
questions. Yeah. So first question, like, can employers legally reduce employee hours without consent?
Yeah, maybe I'll do this one. So, again, it goes to the percentage of salary that you're reducing, or if someone's already in a part-time schedule, right? So anytime an employer is to give a part-time, unless you really want a set number of hours and you want them to be there in that schedule, I always advise an up to number, because that lets you reduce on an as needed basis there. But back to salary reductions and percentages there. Again, 10% salary or hour reductions probably going to be okay. One option that I didn't discuss before when I answered the question was temporary layoffs. Most provinces have a provision in the Act to permit you to do temporary layoffs. Each province has unique rules and regulations and the way it needs to be delivered, how it can be delivered, how long it can be delivered. Do you need to do benefits when they're on it? Can you not? If you do benefits, can you do it longer? When does that kick in as a temporary layoff versus a salary reduction? Most provinces, it's about half in the reduction of hours. It begins to kind of be a little bit of a temporary layoff, and they may be able to get some EI to help cover that difference. But it's a very fact-based scenario too, in that exploration there.
Mm-hmm. Like moving from like a full-time role, like on-site or hybrid, like can an employer change the terms of the contract to be remote? And like, what if an employee doesn't want to go remote? Like, would then be like considered like a constructive dismissal?
Yeah, so yeah, of course, that really can be constructive dismissal. There's a few parts of the employment relationship that are always considered fundamental, and one of them is job location, right? So that works both ways, whether you want to bring everyone back into the office or you want to get rid of the office and tell everyone to work from home. That's a fundamental fixture of the employment relationship. So you either need one of two things. You need permission from all your employees to do so, or you need language in your contract that gives you the power to do so. If you have a written clause that says you can determine the work location and you have total control over that, it's easier to do within reason, right? Like if you're not asking and you're telling, you may lose people and that trust there, but that's really the key there. And then the other thing to consider that I'll plug, since we're talking about remote work, is now that it's become more and more part of everyone's daily life, provinces across the country are looking at how they treat that relationship and what the employer's responsibilities are to the employee based on where they are working. Some acts already consider that. In BC, employers have a duty to provide a safe work environment regardless of where the employee is working. Other provinces are looking at creating the same and saying, hey, if your employee is working from home, that doesn't absolve you from ensuring that they have a safe workspace, a comfortable workspace, ergonomics. Doesn't mean you don't have to accommodate them or assist them to perform their work in the same way as you would in an office. There will obviously be changes and considerations to the fact that you don't really have control over their apartment, and no employer wants to be policing, their employees and, and everything they're doing in their home. But you will need to kind of probe and do some due diligence to demonstrate that you've, at least attempted and made good faith efforts to ensure the employee has a good space to work in. Do they have a desk? Do they have a chair? Things like that, right? Because eventually I think there will be duties probably in every province to inquire about this.
Mm-hmm. And then thanks for that. One more area though I'm thinking now is like around like contractor and employees, right? Like what distinguishes like a true contractor from an employee under the law? And like, are there any risks around like misclassification around that?
Yeah. So there's always a risk of misclassification. And I guess one of the common things people also don't realize is there's layers between full employee and full independent contractor. There is a middle ground called dependent contractor. So I'll talk about, what makes someone a true independent contractor. And there are factors that courts look at, and the number one factor is going to be supervision, right? Are you telling the employee when to work, how to work, all these kind of things? Are you setting every possible rule you can as if they're a regular employee? It's going to be really hard then to make the argument that they're not an employee. Are you providing them with all the tools to do the job? If you're doing that, again, it's going to be hard to argue that they're not an employee. And with these two, there's always the caveat, right? If you've hired someone as an independent contractor to provide customer support between 10 and 3, then obviously it's okay to tell them they have to work those hours, or if your clients are placing those rules on you to say, yeah, you can subcontract the work, but you must give them a laptop that belongs to you so that we're sure about the security. That's obviously going to be permissible. One other factor is the ability for them to increase their income. Can they work for anybody else? Or can they work only for you? Right? Can they work more hours? Can they, are you really just focused on just the deliverable and you don't care when they work, how they did it, as long as the deliverable is really good for you. And that's really the only structure there. And then there is the concept of dependent contractor that I'll plug just kind of really quickly. So this becomes dangerous for companies when they realize that a contractor is working exclusively for them, right? Whether it be part-time or full-time, and that can sometimes make sense in the context and make sense in the industry, right? And I guess one thing I didn't say about this is all of these factors are also weighed against what goes on in the industry. And the CRA and courts have made some determinations that some industries, they've really given up trying to push people into employees. And they understand that independent contractors is the norm. One of them, for example, is the film industry. Back to dependent contractors. So when someone economically depends on you for their income, there is a requirement to provide them with notice. And to rebut all of these, to prove, they're an independent contractor, or to prove you don't have to do notice, this all really depends on the contract you have with those individuals, right? So that paperwork, again, is really key, right? If there are factors that weigh towards them being an employee, but you really want them to be an independent contractor, I always say there's nothing wrong with putting that color in the agreement to say, we are going to provide you the following tools to do the job, because that is a requirement placed on us by our clients to ensure security in the work. Nothing wrong with that. And then, if you ever have a dispute later, a court will look at that and say, well, that was the agreed upon facts, and that was the reason for it. Why would I stray outside that?
Thanks, Justin.
All right. So moving along to the next area. So this is the last sort of area of internal mobility and reskilling. I'm very conscious of time, and I do know that we want to save that. There's been a lot of questions, so I'm gonna kind of go through this one. There's also a little bit of an overlap in this one when it comes to the last area that we were talking about internal mobility and reskilling. Really, what this is redeploying talent instead of releasing it. So one of the smartest ways to avoid layoffs is to look inward. So at the people you already have. If you value that talent and the employees that you have in the organization, tap into that with your existing clients. Or sorry, with your existing employees. So things like identifying transferable skills. Who has the skills? Can we amalgamate those with other areas of the organization? But also remembering that if you do this, is like Justin was saying earlier, make sure that you are updating their job descriptions and that they agree to those job description changes. Upskilling and cross training. If maybe you can't move someone right now, maybe you can prepare them for a future role. So if this is something that, again, this is about being proactive. Get the training that they need, the cross training, get them started on that. Would you rather spend a few $100s in a few weeks training someone, or pay for severance, hire externally later on, or onboard from scratch? Some things to think about. So, and also internal talent marketplaces. So basically a way for employees to find short-term projects, stretch assignments, or open roles within the company. So this can help in two big ways. It gives employees visibility into different opportunities they didn't know might exist. It also helps managers fill gaps without hiring externally, which we all know can be very expensive. So reskilling and internal mobility aren't just retention strategies, they're resilience strategies as well. Yeah, so I think we might have question from Matt around this area.
Yeah, I always seem to have a question on every slide. My apologies, but
That's
just
okay.
from a
That's good.
yeah, like, what legal obligations arise when like an employee's core duties are changed or like expanded significantly?
Yeah, so maybe I'll talk about this a little bit here, and I'll try to be kind of super quick. But again, it comes down to paperwork, right? This is a fundamental change. Fundamentally, it's what they signed up for, and courts consider their duties and responsibilities fundamental to whether or not they decided to take that job. As the important factor on a variety of things, whether the compensation was appropriate. And I always say, in every employment agreement, I always include a little bit of a clause at the end that says, and other duties, as similar to another person carrying on in the same industry, right? To give some flexibility to employers there. So,
like when you're talking about like internal changes, internal moves, I'm assuming that you would probably want to put in new terms in writing,
yep.
especially if there's like a change in salary or like a title or even like a work location. Is that accurate to say?
Yeah, of course, always. I always say papering it is king, and when you're making major changes, I say you can do a new employment agreement if you've got it recently done. You can do a letter, just to outline a summary of the changes. But I always point back to the employment agreement just to double check to make sure it lets you do that. Courts have said, when there's a series of letters, they're like, the rest of these terms, we're not sure that you really wanted to continue on through. So you always want to have some language in there to say that. So.
Yeah, we tend to do a lot of like employment change letters per se, for things like that. Even if you're changing a location, like you said, something in writing is always the best. So really what we want to do is, encourage you all to revisit your workforce strategy and speak with your HR teams. And, when you do come up with these strategies, and ensuring that that you're taking these actions legally, and something that, can be enforceable. Um, and hopefully some of the ideas that I shared about different options that you might have around layoffs were helpful. So we've kind of focused a lot on strategies to avoid these layoffs, but the reality is sometimes layoffs are unavoidable. So whether it's due to financial constraints, restructuring, business line, ending your businesses, there are moments where these workforce reductions are required. And that's just, it's important to understand that. So with that, I'm going to hand this next slide over to Justin to wrap up on what employees need to know when employers need to know when layoffs are on the table.
Yeah, thanks, Laura. So this is always an important topic, and when there's no other options available, it's really important to consider. So I'll take you through some of the key points that I take a lot of employers through. The first one is I always take them through an exercise to understand their risks, right? So like I said at the start, this involves running through all of the documentation for the individuals they want to make changes to. And this is because it'll inform what actions we take for each individual, right? If I'm like, hey, we've got a rock solid employment agreement, it points to the minimums, that's really the minimum that we need to do, and that's what we can comply with, and we'll consider doing more based on how we can, and the financial firepower that we have to do so, and based on the portfolio of all employees, right? Because I know most businesses only got a certain budget for these when they do them. So really the paperwork tends to be key. If I get into an area where I'm like, hey, there is no termination clause in this employment agreement. Therefore, you've probably contracted out of the ESA minimums in your province, and you have to turn to common law. And common law is a much more generous and flexible standard. And courts will look at all of the circumstances around the employee, their age, the lengths of service, the character of their employment, the availability of similar employment, and market conditions, the economy generally, a whole host of things. And generally I say, if you don't properly point employment standards, about 1 month per year of service, unless they are truly an entry-level employee, you might get less, 2 to 3 weeks. About 1 month per year of service is what a court is going to award. But if there are other factors, if the person is close to retirement, they may say, you know what, they've got a year left, we're actually going to award them a year, right? Courts are really a wild west, so I always counsel employers to avoid them. And usually you mitigate this risk by ensuring that you have a proper release when doing so. So I would say, here's the minimums, maybe we'll give you another month or two in exchange for signing the release. And that closes the hole, right? You pay a little more, but you know what the risks are there, and it closes out that risk altogether. Another thing that I always counsel everyone to do is to think about the day of. And that is from everything to how you're communicating to the employees that remain, when are you doing it? How are you doing it? Because courts will look at the totality of what happened on that day. If they say, hey, you did it in the open workspace, they're probably gonna be like, I'm probably gonna award a lot of extra time for this employee, right? If you did it in some other way that doesn't really make sense. I always advise employers to do it in the first couple days of the week, Monday, Tuesday, Wednesday. And that is for a variety of reasons. One is that if someone does have a mental health crisis and you do it on Friday afternoon at 4 o'clock, they're going to really struggle to get help, right? Because this is a huge shock for them, right? They're going to struggle to get legal advice. Another thing when it comes to the day of is if you are getting a release in exchange for the employer, I always say, hey, give them the release, give them the paperwork, and say, we are going to send this to you in 2 days to sign. But until then, take that time to really consider this, read through it, and make sure you understand that. And that is because courts say employers should take the high road, the employee's in shock. They might demand to sign it because they're really just scared that they're going to get nothing otherwise. And if they sign it on the day of, even when the employee has been in court and said, yeah, I really wanted to sign it the day of, they've waived the release and gotten rid of it. So I won't talk too much on the last point. I just say claims for wrongful termination happen to everybody. Probably about in 1 in 10 of the employees that you let go, there will be a claim. Your gut reaction is going to be to react really quickly. I say, take a moment, take a pause, go find yourself counsel. Counsel for the employee is always going to be willing to wait if they know you're going out and getting a lawyer, right? There's going to be deadlines, but at the end of the day, they really want to settle too because they understand the cost of going to court. So they will wait. Don't rush through anything. Take a moment and get counsel, and it'll probably happen about 1 in 10 times. So I think that's really all I have. I want to save some time for questions, so I won't talk anymore here.
Yeah, we are definitely getting close to the end. So there are quite a few questions, some great questions that I'm excited to share with you. Before the questions, though, there is a QR code for anyone that's not on Humi to explore. Happy to book a demo through there. All of these documents that Justin's talking about can be facilitated within our platform through our document management. So Humi at the end of the day would be a good consolidated place to house all of that accurate information. And again, Business Sherpa's webpage there and Navio's law firm webpage is right there for you guys to collect and potentially reach out to. So I'm going to go back to strategic workforce planning side, Justin. This is from Italia. Can you give examples of what type of paperwork you are referring to on the strategic workforce planning side? An example like financial statements, proof of reduced revenues, or employment contracts?
Yeah. So, I mean, when you're doing a reduction, there's kind of two components, right? So I always talk to every employer about what evidence they may have to color the situation and making sure it's all really documented really well. So one component of it is the items that you mentioned, right? Being able to demonstrate that it truly was a reduction in workforce due to financial circumstances. And that is to protect yourself if you get a demand letter that talks about all these other things that really were the reason. And then it's just coming down to the fundamental paperwork. So that's the employment agreement and anything that they've signed over the years for, including letters, changes, your policy book, really tend to be the fundamental things that give employers hiccups.
Right on. And from Natalia again, she mentioned how do you navigate making it optional for the employees to choose voluntary leave / reduced hours when there is a specific need to reduce costs by a certain amount, or when there is a specific need. And then her second part to that question is, this is why temp layoffs seem more useful.
Yeah, maybe I'll let Laura answer that one a little bit, and I can jump
So
into
the
it.
question, how to navigate making optional for employees to choose voluntary leave. I'm just reading the question. Voluntary reduced hours when there's no specific need to reduce costs by a certain amount. So yeah, temp layoffs are useful, like we were saying. I mean, and I know there was another question about that, about temporary layoffs and paying out vacation balances. I'll answer that one as well in this, but it's really about being open with those employees and seeing which employees need, like where in the organization do you need to reduce costs, and then talking and about the different options that you have. And temporary layoffs can sometimes be the answer in this area if it's only something that you feel is going to be temporary. So like Justin was saying, it's different for every province, but I'm going to give you an example. In Ontario, it's like 13 weeks, where a temporary layoff could be useful for an organization that maybe is under, let's say, a time of year that it doesn't, earn as much revenue. And you don't have to, that vacation accrual doesn't have to be paid out at that time of the temporary layoff. But if you do not bring that employee back to the organization within that time frame, that structured time frame, at that time, then you pay it back. Then you pay it to them, whatever was accrued. So it does give the organization a little bit more time to, if the revenue is down, they don't have the money at the time. I've dealt with that on a few occasions as well. It does give an opportunity. It does help the employee because they can, without being totally terminated, they can collect employment insurance. So I guess the key to this is having those conversations with the employees, even if it's individual. So maybe you need to reduce 1 or 2 per department, depending on the size of your organization. Having those conversations and seeing if it's something that they'd be interested in doing. And it's really just about proactive planning and seeing, again, all of these things that we've talked about, like Justin said, we can be very creative, but it's just about being transparent, having the employees buy in with it, and also, ultimately at the end of the day, they have a contract. But as an organization, there's times where you just may not be able to keep the employees. So these are some things that we can talk about with them to avoid having to do those terminations or layoffs ultimately.
Okay, thank you for that.
There's also another question right underneath it, about, are any of these possible with a unionized environment? A little bit different with the unionized environment. Certainly, you definitely need to see what the terms of the collective agreements are and what has been agreed on within the collective agreements. So you definitely want to make sure that you're not going against anything that's already in the collective agreement. That's why it's very important to ensure that when you're making these decisions and this planning, this strategic planning, that you do involve your HR support as well as legal. It's extremely important because they will be able to advise on what that might look like for you if you are unionized.
Yeah, and I think I'll speak from the legal side, is that really the collective agreement in some instances becomes that minimum standards legislation and overrides things altogether. So it really becomes what you need to live and die on there when you're talking to the employees, and what you can and cannot do. So it's always good to be prepared there. And I'd always, I don't do union work on for myself, but I always advise employers when they think that employees are beginning to unionize, or they have unionized, to really go out and get a specialized firm, because it is a very specialized area of the law.
In some cases, collective agreements might be easier because they are so structured and set in stone. But at the same time, when you are having to consider these types of options, it can be a little bit harder to navigate.
Right. One more question here. So with any of these changes that you mentioned, like, how do you balance between making the decision based on the needs of the organization and communicating it in such a way that it does not amount to constructive dismissal? Like, what do you do if an employee disagrees?
Yeah, so I mean, I guess I'll start for a little bit, right? If they don't agree to any of these changes, there's always the ability to do some of it without permission, right? Like I said, some of a reduction in salary, some of a reduction in hours. You can move them to a temporary layoff and things, provided that the paperwork you have permits you to do so. Yeah, you can, right? And but truly then unfortunately, maybe Laura can talk a little bit about this, but that might mean that, for that person, unfortunately, exit is really the safest path there. So.
Yeah, I mean, like Justin said, it's extremely, these times are difficult, and that's why at the beginning we said that these are uncertain times, difficult times. And in these scenarios, this is where we, have to get creative. And ultimately, at the end of the day, yes, we have a contract with these employees, but sometimes these things have to happen. So, if an employee doesn't want to support, some of the options that are provided to them, then at, ultimately the organization, is going through, let's say, something like undue hardship, where there's just no option for the employer to keep the employee employed. So if they're not wanting to explore those options, then ultimately we have to look at the termination of an employee. And again, it's not where we want to go, but it's sometimes just at the end of the day what we have to do. And again, if we can just give you one takeaway from this, I do recognize the time, but it's extremely important to involve your HR and your legal team when making these decisions. Be proactive in your strategies, and have a look at where the organization is at, and try to see any potential for these types of things that might need to happen. And get be transparent with your employees. I think it's important that people really can trust you as an organization if you're open and honest with them about things. But there's so many things you can do to try to avoid layoffs or terminations first. So I hope that you were able to get some really good information from this webinar today. But ultimately, if you do have any further questions or advice, you can reach out to us as well.
Yeah, and I always say when you're doing all of this, I'll say it again, just document everything. If you're doing meetings with people and you're providing creative solutions, nothing wrong with following up after the meeting to say, hey, we discussed the following creative solutions, in case the person's in a little bit of shock. And that also just helps you later if you do need to move to a termination to say, hey, yeah, you're going to make a claim to say the person with short service, or other, unique claims they might make, but we can say, hey, we actually explored 5 options to keep this person employed. Here's all our evidence, here's our meetings, here's, follow-up emails, but at the end of the day, they weren't interested in entertaining any of them. So really, termination was our only solution.
Awesome.
Yeah,
great.
There was also some really good questions here as well. So, I mean, we haven't been able to get to all of them. So perhaps there's a way that when we do send out a follow-up email about this, that we're able to, answer some of these questions for you guys.
Yeah, exactly. So we will have to drop it now because we are past time, but I want to thank everyone for joining. Really good webinar, very insightful. As Laura just alluded to, we will be sending everyone a follow-up email on Monday that will include the link and the recording and a checklist from Laura and Justin. If you guys wish, you can always add me on LinkedIn. If you have any further questions, I can certainly route them over to them as well. I want to thank you guys again for your time. Everyone have a wonderful day. Hopefully the weather's good over there. And again, we're just an email away or a LinkedIn message. So we look forward to hearing from you. Take care, everyone.
Thanks, everybody.
Thanks, everyone.